In making custody and visitation determinations, the judge must look at the best interest of the child, and those are 10 factors that the court must consider and weigh that are detailed in the Code of Virginia. The first factor is the age and physical and mental condition of the child, given due consideration to the child's changing developmental needs. So when the court's looking at that factor, they're looking at what the child's needs are right now, what they can be in the future. Now, if you have a child who has special needs, this factor is going to be very important in the case. The next factor the court looks at is the mental health of both parents, and that's where sometimes you would have a psychological evaluation done if there's a concern or issue with one parent's mental health. The third factor the court looks at is the relationship existing between the child and each one of the parents and their positive involvement. The next factor the court would consider is the needs of the child, given due consideration to their relationship with siblings, extended family, their neighborhood friends, and their peers. So in this factor, the court could look at if a child is very close to, say, the maternal grandparents. What effect would the relationship with maternal grandparents have if father was awarded custody in that situation? The fifth factor the court looks at is the role that each parent has played in the caring of the child now and in the future. So under this factor, the court's going to look at who played the role of taking the child to the doctor's appointments, school projects, extracurricular activities, and just their involvement in the day-to-day caring of the child. The sixth factor that the court will look at is each parent's propensity to support the relationship between the other parent and the child. So under this situation, you're looking at if the child is with mother, is she actively supporting father's contact, communication, and visitation with the child, and vice versa. The seventh factor the court's going to look at is each parent's relative willingness and demonstrated ability to maintain a relationship with the child and their ability to work together. What a court wants to see is two parents co-parenting and reaching decisions together for the benefit of the child. And in a divorce situation, that's going to be hard because you had someone who was your teammate and now they're not. And a lot of times people tend to dig in their heels, but what the court's going to want to see there is that you can actively cooperate with your ex-spouse or your soon-to-be ex-spouse and make decisions for the best interests of the child or children. The eighth factor the court will consider is the reasonable preference of the child. But the court's also going to consider the age, maturity, and intellect of the child. So in this situation, when you have a 4-year-old, obviously, they don't really understand what's going on, and their preference isn't going to carry as much weight. Now, there is not a bright line rule in Virginia where a certain age, at that point, the child's preference is what the court does, because their court is always going to consider the age, maturity, and intellect. So for example, if you have a 16-year-old who says they want to live with their dad, obviously 16, they're getting quite up there in their age, but if they want to live with their dad because their dad lets their girlfriend stay the night and they can smoke marijuana while in their dad's house, obviously that preference isn't going to carry a lot of weight with the court, because that's when the court will look at the maturity and the intellect with the child and why they're making this preference. The ninth factor that the court will look at is if there's a history of family abuse. And the 10th factor that the court will look at is such other factors that the court deems necessary and proper. And this is the catch-all. So if there are things that don't fall under factor 1 through 9, this is where that evidence, that information can be presented to the judge. And the court will look at all 10 factors, weigh the factors, and then make a determination as to the custody and visitation of the child or children.